when and to the degree the peace officer reasonably believes the deadly force is immediately necessary to make an arrest or to prevent escape after arrest if the use of force would have been justified. And 1, the officer reasonably believed the conduct for which arrest is authorized included the use or attempted use of deadly force. Or 2, the officer reasonably believed that there was a substantial risk that the person would be arrested, would cause death or serious bodily injury to the officer or someone else if the arrest is delayed. Under such circumstances, there is no duty on a peace officer to retreat before using deadly force. Deadly force means force that is intended or known by the person using it or resisting it to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the peace officer. Upon the law of self-defense, you are instructed that a person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other person's use or attempted use of unlawful force. The use of force against another is not justified in response to verbal provocation alone. A person is justified in using deadly force against another if he would be justified in using force against the other in the first place, as above set out, and when he reasonably believes that such deadly force is immediately necessary to protect himself against the other person's use or attempted use of unlawful deadly force. A person has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force. A person is justified in using deadly force against another if he would be justified in using force against the other in the first place, as above set out, and when he reasonably believes that such deadly force is immediately necessary to protect a third person against the other person's use or attempted use of unlawful deadly force. By the term reasonable belief, as used herein, is meant a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. By the term deadly force, as used herein, is meant force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. When a person or the third person is attacked with unlawful deadly force, or he reasonably believes that he or the third person is under attack or attempted attack with unlawful deadly force, and there is created in the mind of such a person a reasonable expectation or fear of death or serious bodily injury to himself or the third person, then the law excuses or justifies such person in resorting to deadly force by any means at his command to the degree that he reasonably believes immediately necessary, viewed from his standpoint at the time, to protect himself or the third party from such attack or attempted attacks. And it is not necessary that there be an actual attack or attempted attack, as a person has a right to defend his life and person, or the life and person of the third person. from apparent danger as fully and to the same extent as he would had the danger been real, provided that he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time, and that he reasonably believed such deadly force was immediately necessary to protect himself or the third person against the other person's use or attempted use of unlawful deadly force. In determining the existence of real or apparent danger, you should consider all the facts and circumstances in the case, in the evidence before you, the previous relationship existing between the parties, if any, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the occurrence in question. And in considering such circumstances, you should place yourselves in the defendant's position at the time and view them from his standpoint alone. Manslaughter. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Patrick Wayne Tuter, on or about the 31st day of August, AD 2012, in Dallas County, Texas, did unlawfully and recklessly cause the death of an individual, Michael Vincent Allen, hereinafter called deceased, by discharging a firearm into a motor vehicle that was operated by the deceased, then you will find the defendant guilty of manslaughter as charged in the indictment. Unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, then you will find the defendant is not criminally responsible and say by your verdict not guilty to the manslaughter of the indictment. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you cannot agree, you will next consider whether the defendant is guilty of the lesser included offense of criminally negligent homicide. Criminally negligent homicide. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Patrick Wayne Tuter, on or about the 31st day of August, AD 2012, in Dallas County, Texas, did then and there cause the death of Michael Vincent Allen, an individual hereinafter called deceased, by criminal negligence, discharging a firearm into a motor vehicle that was operated by the deceased, you will find the defendant criminally responsible. Then you will find the defendant guilty of criminal negligent homicide. Unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, then you will find the defendant not criminally responsible and say by your verdict not guilty to criminal negligent homicide of the individual. If you have a reasonable doubt as to whether the defendant is guilty of any offense defined in this charge, then you will acquit the defendant and say by your verdict not guilty. Defenses. Now therefore, if you believe from the evidence beyond a reasonable doubt that in Dallas County, Texas, the defendant on or about the 31st day of August 2012 did then and there, reckless or by criminal negligence, cause the death of Michael Allen, hereinafter called deceased, by discharging a firearm into a vehicle that was operated by deceased, as alleged in the indictment, but you further find from the evidence, or have a reasonable doubt thereof, that the defendant was a peace officer and reasonably believed that the force, when and to the degree used, if it was immediately necessary to make or assist in making an arrest, and that the defendant reasonably believed that the arrest was lawful, and before using force, if any, the defendant manifested his purpose to arrest and identified himself as a peace officer, unless the defendant reasonably believed his purpose and identity were already known to Michael Allen, the person to be arrested, and you further believe and have a reasonable doubt thereof that the defendant reasonably believed that the conduct for which arrest was authorized included the use of attempted use of deadly force, or the defendant reasonably believed that there was a substantial risk that the person to be arrested would cause death or serious bodily injury to the defendant or another if the arrest was delayed, bearing in mind that a peace officer is under no duty to retreat before using deadly force, then you will acquit the defendant and say by your verdict, not guilty. Or, if you believe from the evidence beyond a reasonable doubt that in Dallas County, Texas, the defendant, Patrick Wayne Tuter, on or about the 31st day of August 2012, did then and there recklessly or by criminal negligence cause the death of Michael Allen, herein after called deceased, by discharging a firearm into a vehicle that was operated by deceased as alleged in the indictment, but you further find from the evidence as viewed from the standpoint of the defendant at the time that from the words or conduct or both of Michael Vincent Allen, it was reasonably appeared to the defendant that his life or person or the life or person of another was in danger, then, and there was created in his mind a reasonable expectation of fear of death or serious bodily injury to himself or another from the use of unlawful deadly force at the hands of Michael Vincent Allen, and that the actor under such apprehension and reasonably believing the use of the deadly force on his part was immediately necessary to protect himself or another against Michael Vincent Allen's use or attempted use of unlawful deadly force, then you should acquit the defendant on the grounds of self-defense or defense of a third person, or if you have a reasonable doubt as to whether or not the defendant was acting in self-defense or in defense of another on said occasion, and under the circumstances, then you should give the defendant the benefit of the doubt and say by your verdict, not guilty. Special issue. Now, if you find the defendant guilty of any of the above offenses, and you further find beyond a reasonable doubt that the defendant used or exhibited a deadly weapon, namely a firearm during the commission of the offense, during the immediate flight following the commission of the offense, you will answer the following special issue, yes, and so state in your verdict. But if you do not find, or if you have a reasonable doubt thereof, you will not answer the following special issue, no, and so state in your verdict. Evidentiary instructions. At times throughout the trial, the court has been called upon to pass upon questions of whether or not certain offered evidence might be properly admitted. You're not to be concerned with the reasons for such rulings, and you're not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines what weight should be given to such evidence, nor passes on the credibility of the witnesses. As to any offer of evidence that's been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. The fact that the defendant has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at his trial. You're instructed that if there's any testimony before you in this case regarding the defendant having committed an offense, if any, other than the offense, if any, alleged in this indictment, in this case, you cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offenses, if any were committed, and even then, you may only consider the same in determining motive opportunity, intent, preparation, plan, knowledge, identity, or the absence of mistake, of accident, or of the defendant, if any, as alleged in the indictment, in this case, and for no other purpose. Presumptions and burden of proof. All persons are presumed to be innocent. No person may be convicted of an offense unless each element of that offense is proved beyond a reasonable doubt. The law does not require the defendant prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless you're satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. In all criminal cases, the burden of proof is on the state. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. If the state fails to meet its burden, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. Concluding instructions. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he or she may have heard regarding the case from any source other than the witness stand. In deliberating on this case, you are not to refer to or discuss any matter or issue not in evidence before you. Further, you shall not talk about this case to anyone not of your jury. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given to the testimony, but you're bound to receive and follow the law from the court. After you've retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by your foreperson, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, the court concerning any questions that you might have. After argument of counsel, you will retire and select one of your members as your foreperson. It is the duty of your foreperson to preside at your deliberations, to vote with you in arriving at a verdict. Your verdict must be unanimous. And after you have arrived at your verdict, you may use one of the forms attached by having your foreperson sign that particular form that conforms to your verdict. And I'm signing this charge here in open court. Wyatt Parker, Judge Presiding of the 204th Judicial District Court. Now, ladies and gentlemen of the jury, for your convenience, as I tell you in the charge, I've got forms for you for your convenience here attached to the charge. I know you can't see them from where you're seated, but I'm going to read them to you. They're actually three forms. One is for the manslaughter charge. It reads that we, the jury, unanimously find the defendant guilty of manslaughter as charged in count 2 of the indictment. And if this is your unanimous verdict, all 12 of you agree as to this verdict, then that person you signed as your that you selected as your presiding juror would simply sign his or her name in the appropriate space I provided immediately below that verdict form. If you then the second question, which I've addressed as a special issue, says we further find beyond a reasonable doubt that a deadly weapon was used in the or exhibited during the commission of the offense. And if you did feel that a deadly weapon was used or exhibited in the commission of the offense of manslaughter, then you would have your presiding juror circle the correct answer, whatever your unanimous verdict is, yes or no, and I've got both choices there for you, and then simply sign down here, presiding juror, that certifies to me that's your unanimous verdict as to the special issue. The second form is on the second page, and it reads verdict form for criminally negligent homicide. And again, it reads substantially the same, except for this particular offense. It reads, we, the jury, unanimously find the defendant guilty of criminally negligent homicide. Again, if this is your unanimous verdict, your foreperson would sign his or her name in the space provided there as presiding juror. And then I've got the same special issue in that particular case as well. It says we further find beyond a reasonable doubt that a deadly weapon was used or exhibited during the commission of the offense, and then your presiding juror would simply sign yes or no, or circle yes or no, and then sign the blank there, presiding juror, again certifying to me that this is your unanimous verdict. And on the last page is the not guilty verdict. It just says, we, the jury, unanimously find the defendant not guilty. And if this is your verdict, again, all 12 of you agree, then that person you've selected as your presiding juror would simply sign in the appropriate space provided there. Of course, only one verdict form can be used. Okay? All right, we're ready for closing arguments now. And Mr. Sanchez, or excuse me, Mr. Hayes, I believe you're going to open for the prosecution. Is that correct?
Oh, yes.
Yes, sir.
Judge, if I use 7 minutes, will you let me know?
Yes, sir, I will.
And just to let you know, before the charge goes back to the jury, count 2 should not be, shouldn't say count 2, okay, count 1, just to make a correction. Good to talk to you guys again. It's been a few days since we've had a chance to speak. We look over you guys as things are going on. And thank you for the time and attention you've given us. I can tell that you guys have listened to everything. Maybe didn't want to be here, but like I told you on Monday, I suspect that you found the process as fascinating as I did. This is Michael Allen. And over the last few days, we forget that this is the victim that we're here to talk about. This is Michael, and that's Natalie. And he was breaking the law that night, no doubt about it. He was breaking a law that carried a punishment from minimum 6 months up to 2 years in jail with probation if a jury or judge felt it was necessary, and drug treatment if a jury or judge thought it was necessary. He wasn't breaking a law that carried a death sentence, but that's what he received. He was gunned down like a dog in the street by a police officer. Michael Allen broke the law and ran from the wrong police officer. Police chases are inherently dangerous. But what did you see in that chase that was so dangerous that it deserved to die for? Anything? Did y'all see the same video I saw? Did he intentionally run into anybody? Breaking the law. But what did he do? Does he deserve to die? Did he at any point aim his vehicle at Mr. Tuter? Did he at any point attempt to harm this man in some way? The only harm that occurred out there that night was when this fella decided to ram him, violate office policy, mind you, and ram him. What would have happened if Tuter hadn't rammed Mr. Allen? Did we ever stop to think about that? Because every other officer in that cul-de-sac felt the chase was at an end. They had the cul-de-sac sealed off. He wasn't getting out. And if he did, there were stop sticks 2 blocks away. What would have happened had that fella decided not to ram him? Michael Allen would have been arrested. Given 180 days up to 2 years in state jail, probation if necessary, maybe drug treatment if the judge thought that was necessary. That's exactly what would happen. But he's dealing with a rogue cop. He's dealing with a cop who exercised a maneuver that is not authorized. He put himself in a position where he got scared, I guess. You can't put yourself in danger and claim self-defense. We talked about that in more dire. Every officer on the stand told you that. You can't put yourself in danger and say, oh, now he's coming right for me. Law doesn't allow that. You guys saw the videos and you saw exactly what happened. That guy had a bead on Mr. Allen, slowed down when appropriate, sped up when appropriate, ran right to the side of his car, because that was his intention. That's what he wanted to do. And whenever he stuck his car next to it, he got scared and he shoot at me. The law in this case is kind of what I wanted to talk to you about. It's kind of confusing because there's obviously, I don't think, and I don't think any of you guys think that Tuter left the house that day with the intent to kill somebody. I don't think he woke up, put on his uniform, and said, I'm going to go shoot somebody today. I don't think he intended to do that. I'm going to give him the benefit. I don't think that was his intention. But that's exactly what he did. I don't think he went out there intending to kill anybody, but he was certainly reckless about his actions. He was so reckless, he scared every officer out there with him. They weren't scared of Michael Allen. They were scared of Mr. Tuter. The officers that were actually in the cul-de-sac. They were hiding behind their cars from what? Because they were in his crossfire. His reckless shooting at a cul-de-sac that wound up in a death. So he's guilty of manslaughter. I don't think there's any doubt about that. He admitted to doing it. He didn't like admitting it. Remember when he was asked, is this the guy you shot in the back and killed? How long did it take him to answer that question? See the look on his face? He's like, man. Do you feel any remorse at all, Mr. Tuter? I don't understand that question. Do you feel any remorse at all, Mr. Tuter? Remember his answer? No doubt that he recklessly took the life of Mr. Allen. The issue that you guys are here to decide is, was it justified? I don't think that shouldn't be an issue. You're here to decide whether or not it's justified. And they want you to buy off in two potential arguments versus justification. One is specific to police officers. He was trying to make an arrest, it was immediately necessary, and therefore I shot and killed him. I'll go over that in a minute. The second justification is the self-defense. That has nothing to do with police officers. That's just in general. If you notice, there's no language in there that you get special attention if you're a police officer. It's something the jury consider when you're talking about the objective-subjective standard. The police officer with training hopefully can keep us cool better than me or you. But it has nothing to do. That's just that's a civilian standard. And at that point, if you want to claim self-defense, it has nothing to do with being a police officer. So, and every time I look at it, it's very, very confusing, and it confuses me, and I've been dealing with this for a while, so that's why I'm just kind of, I don't think I can say it enough. It's two very different defenses. In order to find it okay for a police officer to kill a man, you have to believe that it was immediately necessary to use the force that they had to use. You have to believe that the conduct for which the arrest he was trying to make involved the use or attempted use of deadly force, and that's why they were wanting to hit on how dangerous that chase was. You have to believe that the conduct that you're trying to apprehend this guy is so over the top that it may require deadly force, like if you're pursuing a capital murder suspect, or if you're pursuing somebody with a warrant for some type of aggravated assault or shooting at a police officer, something like that. Now they want to try to take that to a chase, and I guess if you want to, you can, but that wasn't the intent. Because you have to believe the conduct for which that particular arrest was authorized to use or attempted to use deadly force. And, or, that there was substantial risk that if they didn't arrest him, that person was going to kill somebody. I ask you again, police chases are dangerous. What did Michael Allen do? Did he ever aim at anyone? The only time he came near a police officer, to me, twice, he swerved out of the way. He did not want to wreck his car. He did not want to wreck into property. He did not want to run over a mailbox. He did not want to hit a car. He wanted to get away. There was no intent to hurt anybody. He had plenty of opportunity to do so. He wanted to get away. So for a police officer to come here and say, well, yes, I shot at him somewhere between 37 and 41 times. Yes, I did that. Because I was scared, or because I thought I had the right to, or because he could have hurt somebody. Every one of us in a car could have hurt somebody. He said it could have. He said, no, what did this officer say today? Maybe, might be. He said it might be situation. Remember, it's got to be immediately necessary for a cop to kill a man. And the second defense I want you to look at is self-defense. And self-defense it's different, it's more complicated. If you and that also encompasses defense of a third person. But if you truly believe you're in danger of being killed, then you can kill somebody. If you truly believe you're in danger of getting hurt, serious bodily injury, that you're going to end up in the hospital, you can kill somebody. And if you bring it up, the jury has to believe it beyond a reasonable doubt that it wasn't self-defense. But it has to make sense. Whenever you try to use that defense, it has to make sense.
7 minutes.
Thank you, Judge. So you've got to go back there and think about that. Does it make sense? Does what Mr. Tuter said to you make sense? Well, he tried to parrot the statement that he and his lawyer crafted after about 10 or 11 days after the incident. Have you ever heard of an investigation quite like that? Have you ever heard of a situation in a shooting where the police arrive, there's a man who's been shot in the back, dead, a car shot up, a defendant just walking around, unhandcuffed, and the cops say, well, I'm going to let you go home. Go watch these videos, go talk to a lawyer, and when you feel like it, come on down and tell me your side of the story. Tell you what, you don't have to tell me, just write it down. You and your lawyer can figure out whatever you want to. Could you imagine that situation? Do you think if you'd been arrested, would they let you do that? You sure wouldn't. But police get special attention. You heard from the Mesquite officers. We didn't call them, and they certainly, I think they're going to tell you that. And the reason we didn't call them is I think it's apparent that at every corner they tried to sabotage the investigation. They either didn't do anything, or they didn't take notes of the few things they did do. That's the shoddiest, crummiest investigation. Rest assured, most of the time they're a much better department than that. But they have no problem covering for cops. Because after all, of the 20 or 30 cop shootings that Investigator Phillips has been involved with, only one of them got done. And they tried to keep this from forgetting about it. The grand jury disagreed. Then blue line. Unfortunately, there's a culture where cops cover for cops. And it's just as bad to omit doing something than cover doing something. And that's what they did. Every officer who was in that cul-de-sac was from Garland. And every one of them told you Tuter was reckless. Tuter fired in my direction. He fired in every direction. His behavior was uncalled for, and it was reckless. Every Mesquite officer came in here and told you, well, yeah, I wasn't there, but I looked at these videos, and he's a cop. He can do whatever he wants. Phillips was finally honest enough to tell you that. Did you hear the last thing he said? Cop can do whatever they want. They're going to be okay in your book. Yep. This too is Michael Allen. This is Michael Allen after he had a run-in with Mr. Tuter. He's laying there on the street after being dragged out by a truck, by his face, laying there dying if he's not already dead, because he was trying to get away. There's no law that justifies police behavior like this. There's no law that says you can shoot someone in the back and kill them. As I pointed out, and I think it's pretty obvious, Tuter was in the absolute safest place he could have been. A vehicle trying to go forward, stuck in place, going nowhere. If it did happen to break free, it would have gone forward. And he was right behind it. What did he do when he was behind? In the safest place he could have been in that cul-de-sac, he leveled his firearm at the back of Michael Allen's head and shot 5-6 times. No way that anyone or any reasonable police officer can ever say that. He can't even convince that of himself. He tried. At the end of the day, we're going to ask you to go back there and talk about everything. I'm going to sit down. I think you'll hear from them, and then you'll hear from Mr. Sanchez. And what we say is not evidence. This is our opinion. You heard the evidence. You saw the exact same evidence that every one of those officers saw in that crummy investigation. I bet you had some questions you'd like to ask. They sure didn't. Hopefully y'all are a little bit more inquisitive than they were. Hopefully you care just a little bit more. Because there may be a headline in this case, and it may say, cop shoots unarmed man 41 times. And you got to decide how that headline ends. Is that okay? Cop shoots man in the back, kills him because he was trying to run away. Is that okay?
Right. Mr. Shook?
Okay, please report.
Mr. Shook?
Members of the jury, on behalf of Patrick Tuter, we too would like to thank you for your patience and time in listening to this case. It's been a long trial. It's in the holiday season. We've taken you from your families, we've taken you from your work, your daily lives, and you've been very patient. You don't have any choice in the matter of coming down here. If you're selected on the jury, you don't have a choice about that, but you do have a choice about listening, paying attention, and you've all been very attentive. And we thank you for that, because you know how important this case is, how very important it is to Patrick Tuter. He's accused of manslaughter. His life is in your hands. You've been patient, you've listened to a lot of evidence. What I want to talk about is what we talked about on Monday, some of the law, and how it applies to the evidence in this case, and some of the facts. And Mr. Rogers will give you his thoughts. We spent a lot of time talking about, under Texas law, when an officer can use deadly force. And there were some people on the jury that had problems with different areas of the law, and they were honest with us, and they're not on this jury. We had to be sure that the people that made it on this jury understood the law and agreed with the law, and could apply the law to the facts of this case. As a jury, it's not your job to solve a case. It's not your job to seek justice for the deceased, to make the deceased family happy, to satisfy the prosecutors. It's your job to try as unemotionally as possible, because trials are emotional, look at the facts and apply the law in the case. That's what you have to do. Anytime there's been a violent death where a family's lost a family member, it's hard. They're here in court, they watch, it's hard. This is not what we call a feel-good decision by any means. But you can't let your emotions and the emotions that happen in the case interfere with your decisions. You have to decide these facts and the law. I will trust you'll do that. Now, the judge has given you the charge. It's long, but it's important. And it talks about two theories, defenses in this case. That yes, a police officer can take a life under these conditions, and it's a defense. And it's clear, the judge sets it out, that in the course of his duty, a police officer can use deadly force if the officer reasonably believed the conduct for which the arrest is authorized included the use or attempted use of deadly force. If whoever an officer is trying to arrest for the offense, during the commission of that offense, if they are using or attempting to use deadly force, then they can use deadly force if it's immediately necessary. If another officer, another person in those same exact circumstances, and it has to be viewed from that person's circumstances, would use deadly force in that situation. That's why there's so much testimony on how Michael Allen was driving and the danger he was to anyone he may have encountered in there. There's no requirement under the law that he hit someone, that he maimed someone, that he killed someone. Only that he's attempting, and by his very actions, is creating deadly force. The law also supplies another way to do that. The officer reasonably believed that there was a substantial risk that the person to be arrested would cause the death or serious bodily injury to an officer or someone else if the arrest is delayed. And under such circumstances, there's no duty for a peace officer to retreat before using deadly force. Again, there's no requirement that someone actually be hurt, but there's a substantial risk at that time. And there's also the law of self-defense that applies here. Under either theory, the defendant is entitled to not guilty. Both theories require the jury to view the facts from the defendant's standpoint. Everything that occurred was going through his mind at the time. And it's not the defense's burden to prove that to you by any means. The law is clear. The burden of proof is on the state of Texas, this table right here, and it never leaves. It never leaves. If the evidence is raised, it's self-defense. If this evidence is raised that Patrick Tuter, as a police officer, killed under these circumstances, they have to prove to you beyond a reasonable doubt that it didn't happen that way. And if they can't do that, if they can't reach that high burden,
Excuse me, Mr. Chair. I think he's conflating the two issues. That the burden only applies to self-defense and not to deadly force and arrest. I think it seems to me he's conflating the two issues. I want to make sure he makes that clear. So I would object to confusing the two laws.
Go ahead.
if they can't meet their burden of proof beyond a reasonable doubt, you have no choice. You must find the defendant not guilty. It's not our burden. It's the state's. That's the law. Now, what do we know? We know that on this day, Michael Allen was driving a truck that was wanted by the Saxony Police Department. No doubt about that. That license number. And Patrick Tuter was a Garland police officer on duty. He was doing his job, and he alertly saw that truck. He said, that's the one. There's a boa. 2 days prior to that, that truck was involved in what? The felony offense of evading arrest. And he went behind it, got close to it, didn't turn on his lights right away, followed procedure, and asked for backup because of the circumstances surrounding it. Officer Norris arrived soon after behind him. Then Michael Allen, once Officer Tuter got behind him, started to run. Started to run right away. And for the next 28 minutes, he drove the most dangerous way possible. 60 miles an hour, 70 miles an hour, 90 miles an hour, over 100 miles an hour. Ran through at least 7 red lights, 8 stop signs, went up in a yard, came close to hitting other vehicles. It was like a missile out there. Sheriff Cook said, a missile. In fact, Sheriff Cook was very, thought precisely put it, look, during this chase, when he started evading, he soon started using that car as a deadly weapon. The law doesn't require that he maim anyone, that he kill anyone, that he hit anyone, that he ricochets off anyone, just the manner in use it. And anyone with an ounce of common sense, 1 small ounce of common sense, knows by what you saw in that video, Michael Allen was a danger to anyone he might have encountered, and he wasn't going to stop for anyone. Now, he didn't hit anyone, but you don't reward him for that. There's no defense that, well, he drove real good. He's real good at evading arrest. He seemed like a veteran at it. Which maybe that's the reason he ran. Because that car was wanted in an incident just 48 hours before. Maybe he drove in that manner and wouldn't stop for anyone because in his system was methamphetamine. The medical examiner said that's the type of level we see in people that abuse methamphetamine. And it affects people in a bad way. Maybe he ran because he had a felony possession of methamphetamine right in that console next to him. And he didn't want to go to jail. But we know he wasn't going to stop. And you saw the manner in which he drove. He was using that car as a deadly weapon. He was a danger to anyone that encountered him. If you'd lived in those neighborhoods he was going through and come outside to see him, would you say, hey, look at this guy. Let's go outside. Let's watch. You let the kids come up. This guy's really good. No, you would get everyone in. You'd get him away. If you knew your children or your wife or your husband were on the road and he was coming by, you wouldn't want to be anywhere near him because he's a danger. And that's what the officers had to stop. And that was Patrick Tuter's duty to stop. But Michael Allen wasn't having any of it. Now, you know what you can see from the video, and Patrick Tuter told you, look, they came up, and we've seen it a lot of times now. Came in that cul-de-sac, and he was still not stopping. Michael Allen started going through that yard. Patrick Tuter wanted to get in front of him. They're making these decisions in split seconds. We've seen it in slow motion. This is happening in seconds, and they collide. Well, that wasn't stopping Michael Allen. His vehicle swings around, he goes forward, and their vehicles are hooked up, and Michael Allen is full on the throttle, dragging Patrick Tuter backwards. And he can't get free. He's telling you this is all happening in a matter of seconds. He's trapped. He can't get out his doorway, he can't go this way, and he's trapped. And right next to him, he can see Michael Allen. And he told you, I saw him pounding, he was mad, and he reached this way. We know that from the photographs, and Detective Moore, the crime scene officer, told you, he didn't open this console, but it was open, and that's where his methamphetamine was found. Patrick Tuter didn't know that. He doesn't know he has a gun, and that's what issues like apparent danger are. It's in your mind of what you see, but he sees him go that way. He knows it's dangerous because this car's going, and he knows there's been a collision. He doesn't know where Officer Norris is. He knows other officers are coming. This is all going through his mind. He said, I thought I was going to be shot in the face. Is that not reasonable, the way Michael Allen had driven for the last 28 minutes and didn't want to be stopped under any circumstances? Is that not a reasonable assumption that could happen? In this matter of seconds, he has to make a decision. And he starts firing in that fear. And they make a big deal of how many shots, but that clip was done in about 4 seconds, all right together. And it had no effect on stopping Michael Allen. And he reloaded quickly, and as the cars began to grind by, he fired again in quick succession. And the entire time he was in fear. And the entire time he knew he had to stop Michael Allen. And the law allows him to do that. And they haven't proven beyond a reasonable doubt their case. Now, to try to do that, they called their star witness, Officer Norris. Mr. Sanchez made a big deal in his opening statement about you're going to hear from him. And he took the stand. And Officer Norris, they carefully elicited questions from him. And you heard him. He said that he ran the car. And then he got out of the car. And that he looked in and he saw Michael Allen with his hands attending to it, and a woman balled up on the floor. That's what Norris said. And that he was going to walk up, and I can't believe he would even contemplate doing this, walk in front of that car while Michael Allen is just on the throttle. If that car broke loose, it was going to shoot like a missile out there. And just try to undo the key, try to turn the car on. Now, in the cross-examination, we learned that, you know what, he left those facts out of his written statement. All those facts out of that written statement. And 1 month later, when he had a typed statement, which carefully had warnings, put in all the details, he said he forgot to put those facts in too. So 4 years later, now he's added these very critical facts that he got out of his car and walked over and saw these things. And of course, after he's confronted on cross-examination, when the video, and thank goodness that helicopter was up in the sky. Because if we didn't have that overhead view, you would have thought Officer Norris walked right up to the car and looked in and saw this. And that Patrick Tuter had to be lying. But that video was there. The helicopter was overhead. And Norris was confronted with what he saw. And it couldn't have happened. The cars come in. Norris says he walked up. Here's the door open. He's not out. He's not out. He's not. There's the shots fired there. He's not out of the vehicle. Shots are being fired in rapid succession. Were you standing? Do we see you standing? No. He doesn't get out of that car. But on direct, I've got the testimony right here. Mr. Sanchez asked him, did you get out of your car? Can you look directly into the cab? Yes, sir. Basically the distance from the hood, 4 or 5 feet, so closer than you and I are right now, yes. I mean, if I was standing in the middle of the floor halfway, probably by that picture maybe. Even that close. Yes. So you're that close, looking into a car, and Officer Tuter's on the other side where you're standing, correct? Not sitting in his car, you are standing, correct? Yes. All right. What did you do when you got out of the car and approached and looked in? That's when he talks about he wanted to turn the car off.
15 minutes.
Thank you. What did you see? I saw a female curled up in a ball. Then I saw the driver just trying to get away. And then the other question from Mr. Sanchez. Because at that point, you were probably as close as Patrick Tuter was after you'd seen him on the video, right? Right. You know how close Patrick Tuter was. Side by side. They asked this question. Because at that point, you were probably as close as Patrick Tuter was after you've seen on the video, right? Right. When you're walking over there to do that, what happens? I hear two pops. Folks, it didn't happen. I don't know why he made that up, or if he's just rearranged the facts or things he's heard in his mind. But that's what they presented to you to prove their case beyond a reasonable doubt, that witness. Maybe they never showed him this video. I don't know. You can look at it as many times as you want. But he's not out of that car. That door's open. He never gets out. Patrick Tuter's probably shot 17 times by then. He didn't go over there and look in the car. You heard questions after his credibility was destroyed on cross-examination of, well, maybe he could see it from his car sitting down. Don't buy that. If those were the facts when they interviewed him and they wanted to present him, don't you think you'd have heard those questions? No, their questions were clear. The question is, why did they put that testimony on in that manner, knowing that Norris is never on that video where he testified he was? Why did they do that? Are they that desperate? But you heard it. You saw his reaction. You saw what they tried to prove in that testimony, but it can't be true. You can't believe him. You can't believe the credibility of their case. Why did they elicit that testimony in that manner? Did they think maybe they could slip this one by us? I mean, yes, you only saw the video once before that. Sure. You've seen it a lot since Norris has testified. It didn't happen the way he said it did and the way they questioned it. Folks, they never met their burden after Tuter. It's unfortunate. It was horrible. Mike Wellen lost his life, but he was doing everything possible to get away from those police officers. And if he could have kept going as he's floating on the throttle and could have broken free, he'd have shot out of there like a missile. He didn't care who was in his path. He made a decision in seconds. It's a decision he didn't want to make. It's a decision he had to make. Thank you.
Just a moment, Judge.
Yes, sir.
May I please the court?
Mr. Rogers.
Mr. Shook, Mr. Snyder, Patrick, ladies and gentlemen of the jury. Ashamed to admit, as long as I've been doing this, I'm scared today. Not the type of fear we've been talking about. No one tries to kill me when I do my job. We sit here and we come in here and we discuss split-second, tense, dynamic, life-threatening situations, and we analyze it over and over, and we diminish it and we demean others. It's not that fear. I'm scared. The stakes are high. This man's life, his freedom, his future are in my hands. And I'm scared. I'm scared I'm going to leave out something. I'm scared I'm not going to say and find the right words and use them in the right way and arrange everything that will resonate with you. I'm scared that the state has distorted and manipulated and put on lying testimony, and that this man will suffer for it. I'm scared that the issues have been turned upside down, that they've tried to shift the burden to us, that we have to prove innocence when he should be presumed innocent. I'm scared. But then I stop and I think And I go back over the credible evidence and who put on the credible evidence and the facts of that night, starting at about 12:50 a.m. And I'm comforted, and I know that you wouldn't be sitting there if you weren't going to be true to your oath. You wouldn't be in that seat if you weren't going to be fair and impartial. You weren't going to be in that seat if you weren't going to hold them to their burden that they try to shift to us. So I'm comforted. And let's discuss some of the things that they try to do, some of the evidence and the testimony, and what really happened. On August 31st, 2012, Patrick Tuter was being vigilant. Patrick Tuter had served his country. He had volunteered to join the Marines after 9/11, had served in Iraq, had put his life on the line for our country already. When he came back, he returned to his hometown of Garland, his wife, his family, and he decided, you know what? I want to protect and serve. And so he became a Garland police officer, starting in 2006. And night after night, Patrick Tuter put his uniform on, he holstered his weapon, and he went into the night to protect the people of Garland, to protect them from people like Michael Allen, to protect them from criminals who believe it's more important to do their drugs, to get away with felonies, criminals who have no regard for human life. As a police officer, you don't know what's around the corner. You don't know who or what you're going to see or meet or confront. But we lie in our beds and we know that we're safe because men like the Mesquite police officers and men like Patrick Tuter kept us safe. And he's being diligent, and he has the information that this white pickup truck, BT94C, with that specific license plate, had evaded Saxe police. Had evaded to such an extent that they lost him. They lost this truck. So be on the lookout. They're on the lookout for this truck. And you know that this truck does not want to meet police. And so he sees the truck and he gets behind it. And he's very calm, he's very collected, he does what he's supposed to do, he calls for backup. Unfortunately for him, it's William Norris that backs him up. Because William Norris didn't seem to be much help in all this. William Norris didn't provide much help in that cul-de-sac. William Norris gets behind him, and you can watch Norris's video. He's behind, well behind Patrick Tuter for most of this chase. It's Patrick Tuter that it becomes and is thrust on the front line to deal with Michael Allen. And he does the simple act of turning on his overhead lights. And he's ready because he knows this truck has evaded before. So he's ready, but you don't want it to happen. Because the lights go on, and if the worst thing that could happen at that point is a state jail felony and drug treatment, then why didn't Michael Allen pull over? If the worst thing that could happen for Michael Allen was just some probation or a few months in jail, then why did he take off? Why did he decide to use his car as a weapon? We don't have to answer that. Explain that to me, state. Prove your case. What harmless motivation did Michael Allen have? You saw a determined individual not to go into custody, not to be inconvenienced with a night, a day, or a few months in jail, not to ever go to jail. You saw a desperate, committed, dangerous felon. By his actions. And Patrick Tuter, we put him there. We said, Patrick, get on the front line and get this guy into custody. And what did Patrick do? He stayed behind him. You heard him on the radio. He was calm, collected, calling out the chase, getting other units involved, and staying behind the missile. Staying behind the missile as it burst through the night, coming upon people and innocent citizens who didn't expect to see that, who shouldn't have to deal with Michael Allen because he has meth in his car, who shouldn't have to deal with the danger of a 120-mile-an-hour car coming up from behind him. You think Michael Allen had great control over his truck with the meth racing through his system? They make it sound like this is a fun day at the go-kart track. The 7 red lights that he blew through, was it his plan to time those red lights where a citizen wouldn't be driving through? Or but by the grace of God did we get lucky? The 10 stop signs that he blew through, was it Michael Allen's grand plan with the meth racing through his system? As he got up to speeds of 90 and 100 miles an hour, was it his plan that he was going to time it just right so a citizen or a civilian or another officer wasn't driving through there? No, by the grace of God, that didn't happen. Patrick had the helicopter to help him. You see, at some point he called for the helicopter. He was already thinking about how to make this as safe as possible while recognizing the immediate need to get Michael Allen into custody. Because this truck, and I think it's a reasonable deduction, Michael Allen was driving it on August 29th. His mom said he was driving the truck on August 29th. So you see, if you don't get this man into custody, then what's next? Who's the next officer? Is it a Wiley officer? Is it a Murphy officer? Is it a Mesquite officer? Who is going to have to confront Michael Allen? Patrick does it. Patrick does it for us. And he stays vigilant, and he stays diligent, and he stays calm and collected. Lieutenant Lacey, just overall, there are probably over 130 years of law enforcement experience that have come in here and told you that Patrick Tuter acted within reason, within his authority, and did exactly what he was supposed to do. He was fully justified in everything he did. It starts with Lieutenant Lacey, who's seen more chases than anybody in this courtroom combined, because he's the one that gets up in the helicopter and makes sure the officers and the citizens are safe when officers are trying to confront a dangerous fleeing felon. And he told you, Michael Allen put lives in danger. He put civilian lives in danger, and he put officers' lives in danger. And Lieutenant Lacey saw from his helicopter as Michael Allen, going through that neighborhood, came towards Matt Perry, and Matt Perry had to get out of his way as Michael Allen continued careening down into the neighborhood. Lieutenant Lacey told you that you put yourself in the shoes of the officer that's on the front line, that the standards that they're trained on are Graham v. Connor, a United States Supreme Court case that says you don't look at it with 20/20 hindsight.
I'm trying to quote law that's not in charge. I think the law they're obligated to follow is in charge, then proper.
Follow the law that's in charge.
He told you what they're trained on, Graham v. Connor. That you look at it from the officer's perspective, and what Patrick Tuter was chasing was a dangerous, deadly felon. That's from Lieutenant Lacey. You heard from Matt Perry. Matt Perry said he thought Patrick Tuter was reckless, yet they don't get any details. Like, okay, Officer Perry, tell me about the bullet that passed your head, or tell me about which shot exactly came, where were you, which shot came in your direction. No details. Just from his perspective, 2 cars down, he thought Patrick was reckless. But that's not the standard. The standard, we don't even know what Officer Perry thinks reckless is. But he did tell you that when Michael Allen was careening through that neighborhood, that Officer Perry thought he was going to stop, and he testified he thought he'd use stop 6, although after I confronted him with some testimony, he remembered he didn't have stop 6. So he was there. He was at least using officer presence in his squad car, and Michael Allen came straight at him. And Matt Perry told you that he was placed in fear of death or imminent serious bodily injury. That's aggravated assault against a police officer, that he had to take evasive action. Matt Perry told you that. He also told you, contradicting what they're saying, that he believed that if Michael Allen had been able to turn around and his car was there and they had their cars lined up, that Michael Allen would ram them based on the actions that he saw. That's what Matt Perry told you. So Matt Perry tells you that he sees deadly conduct. He tells you he fears death at the hands of Michael Allen. He tells you that he doesn't believe that putting your cars in the cul-de-sac would stop him. Officer Griffith came on the stand and really didn't tell us much of anything. He got there afterwards and is not a witness to this. He added statements different than he said a long time ago. I'm not going to waste my time on him. Then we have their star witness. Out of all this, you want to talk about a shoddy case? The state's star witness got caught lying. Pull it up. Very rarely in a trial do you actually catch someone in such a distinct, bald-faced lie. So you're that close. So this is the state questioning Mr. Norris. So that you're that close, looking into the car, and Officer Tuter's on the other side where you were standing, correct? Not on the video. What did you do when you got out of the car to approach and looked in? I mean, my objective was to either put the truck in park neutral, try to turn the ignition off just to stop the truck somehow. You can scroll up, Grant. So, Officer Norris is telling you 4 years later that he got out, after ramming the car, he got out of his car and just calmly walked up to this truck that had committed aggravated assault against Matt Perry by threatening him with imminent serious bodily injury, had led officers on a high-speed chase for 25 plus minutes, then was locked in side by side with another officer that's wheels were spinning 90 to nothing according to them. So he was just going to calmly, in that madness, get out, and turn off the ignition. And he's telling you that's what he's doing. That's why he got up so close. But yet the video says different. You can scroll up. So keep going, Brad. And as he's walking over there, what happens? I hear 2 pops as he's walking. So as he's walking, he hears gunfire. To be honest, I thought it was a tire had blown out. Keep going. As a matter of fact, he felt comfortable walking up to it to reach in and turn off the car. After you heard the 2 pops, what did you do? I guess I froze for a minute. So here's this. According to the video, we should see Officer Norris ram the car of Michael Allen, get out, walk towards the truck, and then stop and freeze, according to his direct testimony that the state put on. Keep going, Rick. Are you making this up, that you saw his hands on the steering wheel when you walked in there, when you walked up to the car? See, they can't change it. They're going to try and show you the video and show you shadows and try to say, well, is this the ghost of Norris? Is this the apparition of Norris? They're going to try to do hocus pocus with that video, but you have your own 2 eyes. And they've already committed him to this story, that he got up and casually walked up and saw Michael Allen at the go-kart track. Just, hello, officer, I'm just trying to mosey on about my way. I don't know why Officer Norris lied. I don't know why they put on a liar, but they did. I clarified. You're saying you got out of the car and stood up, and that's when you could see into the truck. Show me on the video where we see you standing up. You see you there? No, sir, I don't. By that time, you said you stood up and you'd seen the suspect's hands, and correct me if I'm wrong. I said when I got out of the car. He corrected me. Okay. By the time, so then I'm confronting him with the video. We've seen the muzzle flash, and he still hadn't seen his hands. He has to admit when confronted by actual evidence. Keep going, Rick. Then we talk about, he said Patrick was reckless. He went to counseling. He had all these terrible things happen to him because Patrick Tuter defended his life. But you don't know where he was aiming at or where he was shooting. No, right? Before you sit there and come here and keep going, Ray, you should have the details, shouldn't you? Yeah, I guess so. To this day, you don't know where his bullets went and what direction they went, do you? Right. He's just going to agree whatever they want him to say. He's their puppet. He's their only witness that they have to try and testify against Patrick. And if he's shooting directly into that truck, you don't have any evidence that he shot in your direction, do you? Right. None of these shots are going in your direction, are they? I didn't know at the time. So just because he feels like his feelings are hurt, because he doesn't have, it didn't happen. His life was never in danger at the hands of Patrick Tuter. His life were at the hands danger at the hands of Michael Allen. And he's told you this story about how deadly force isn't necessary. And then he admits on the stand that he committed aggravated assault with a deadly weapon. Okay, so you committed aggravated assault with a deadly weapon, yet you didn't believe deadly force was necessary, correct? Yes. And keep going. Then he has to correct himself because he realized where he's put himself. And at the second, when he rams the car, seconds before Patrick Tuter pulls the trigger, Officer Norris has to admit that deadly force was necessary. That's it. Let's just take Officer Norris's testimony and throw it in the trash where it belongs. Where does that give them? What does that give you? Okay, we're just going to sit up here and scream 41 shots. we're going to play games with where are the other 4 bullets. Well, the only reason we say 41 shots is if Patrick's magazines were full, then that's 46 minus the 5 that he had left is 41. The only evidence of any bullets, casings, and everything is 37 shots. 37, 41, doesn't matter. But they can't sit here and say, where are those other 4 bullets, because there's no evidence of that. They can't shift the burden to us and say, well, we can't find these 4 bullets, so they must have gone somewhere dangerous. No. No. Prove your case. Prove it. So then you have the physical evidence. You have the medical examiner that tells you that Michael Allen had meth racing through his system, that he had to have consumed methamphetamine that day. And then they rest. And then that's it. And then I say, okay, I'm going to call the investigators that investigated this case. I'm going to call 75 years of experience to tell you about this case. I'm going to call Detective Trokel to tell you what he did, what he saw, and why he did it. And what's his job? His job is to decide whether a Garland police officer came into their jurisdiction and killed someone without justification. And he did his job. They're trying to smear good men who have years of experience, who have investigated hundreds of homicides, robberies, assaults. And just because they don't like their conclusion, they're going to stomp their feet and call them names without any basis or justification. And that frightens me. That frightens me that a prosecutor would come here in the state of Texas and besmirch and smear detectives, experienced detectives, for doing their jobs because they don't like their conclusions. Because you know what they're applying? They're applying their reason and their common sense and their training and experience. And they're looking at it from Patrick's perspective. And they want to cry about his statement. Well, he came out here. He doesn't have to testify. He doesn't have to testify. But he came here. Patrick Tuter got on that stand and looked at each and every one of you and explained why he did what he did and subjected himself to cross-examination and irrelevant questions that had nothing to do about his use of force that night. You have his dash cam video. You have his actions that show how calm and collected he was. You have him putting it together. You have him seeing Michael Allen drive at speeds down 2-lane roads over 100 miles an hour. And no, he doesn't have to hit a car. He doesn't have to go directly at a car. His mere trying to flee, doing everything he can, and that missile, that's what puts the 60 or 70 civilians in danger. And Patrick, as they go into the neighborhood, he's calling the chase, and he's hoping this guy will pull over. He's hoping it will end peacefully. But as time goes on, he realizes this guy's not going to stop. This guy is going to kill somebody. Michael Allen, with the meth racing through his system, is going to kill somebody if I don't stop him. And they go into this neighborhood, and he's doing 100 things while trying to follow this maniac through this neighborhood. And he sees the truck careen up into a yard. And Patrick's thinking, this is not getting better. This is escalating. And if I don't immediately get him into custody, he's going to kill somebody. And they end up in that cul-de-sac. and Patrick's making split-second decisions, and as they enter that cul-de-sac, he's hoping the madness will stop.
5 minutes.
Thank you, Your Honor. And so he makes split-second decisions. And we come in here 4 years later, and we play a tape slowly, step by step by step. Well, what were you doing here, Patrick? Well, you had well, we can all tell us what you're doing now. Then what are you doing now? No, that's not how life happens. That's not how Michael Allen comes into our lives. He comes into our lives because he's committing crimes. Split second. How do I get this guy off the road? What am I going to do? I'm going to block him. And then he's have to navigate. There's trees. There's houses. What am I going to do? And then he miscalculates. And if they had a different conclusion, why didn't they, the state, with the burden, bring us a crash investigator to tell us something different? Because they want to use speculation. They want to use inflammatory questions to try and steer you off the track. Even though it's their burden, why didn't they bring a crash investigator to say it happened a certain way, to say it had to happen a certain way? Patrick said, I'm trying to cut him off. I realize I can't. We collide. And then instead of giving up, okay? Michael Allen, it stopped. All right? You've crashed with a police car. It's over. He guns it. And he guns it. He guns into Patrick. And he guns the vehicle. And he's not letting up on the gas. If he lets up on the gas and puts his hand out the window, then it's over. And Patrick is face to face with violence. Because he's seen the violence. He's seen him manipulate a deadly weapon for 25 plus minutes. And he's face to face with it. And we see by the photos that these shots are coming in at a 90-degree angle. When in Patrick's dash cam video, you have a clear view of Michael Allen in that. This isn't an 18-wheeler versus a Kia. This is a squad car and a truck, and the height differences are not what they try to tell you. And if they want to prove different, bring us some scientific measurements, because again, it's your burden.
Well, Judge, I guess I'll object because the investigators failed to investigate, the evidence wasn't there, which I think was made clear. So to implicate that it's our fault to make them investigate is an improper jury argument.
Do you have a legal objection? Because you're the state and they have the burden of proof.
Wait a minute. Address me.
That was a legal
Objection's
objection.
overruled.
You can't tell
I
misinformation.
overrule the objection. Continue your argument.
I'm sorry, I thought they were the state. They have the burden of proof. But the investigators had all the information they needed. Because based on what they saw, based on reason and common sense, they knew that Patrick could see into that truck. And what does Patrick see? He sees the torso move down. And what does that tell him? After 25 minutes of violence, with this car gunning and grinding against him, this guy's about to shoot me in the face. And so he immediately reacts. He immediately reacts because he doesn't want to get shot. He doesn't want his partner to get crushed. Because while this is going on, he feels another collision from his back left. He doesn't know if Michael Allen's rammed a car or if a car's rammed Michael Allen, but it's reasonable to believe that Michael Allen's rammed a car. So he believes Officer Norris is getting crushed. He doesn't know that Officer Norris is going to sit in his car and then eventually run down the street. He wants to save the life of his partner, so he acts. And it's not working. And he shoots, and he shoots. And it's not working. And they want to talk about 37. But like Investigator Hanley told you, they've done tests with 95 bullets from a high-powered assault rifle. None of them got through the other side of the truck, and it's not working. And he's trying. He can't He's trying to process this, and the car is gunning and gunning and gunning. And he keeps trying desperately to live. That's what's going through Patrick's mind. Don't kill my partner. And if Michael Allen gets away, he's going to kill somebody. And then he gets to finally get to the back. And they make it sound like he sauntered up lazily up there, like, hey, nothing else going on. No, he ran to the danger. He did what we want him to do because he believed it was immediately necessary. And if he didn't get Michael Allen into custody, he was going to kill somebody. And he's not sitting there looking at the spin rate of the tires to say, oh, wait, it's going forward, it's going backwards. He gets out of his car. He sees the mayhem still going on. He draws his weapon. He has to dodge the back of the bed and still believing that he or his fellow officers were in immediate danger because the threat had not stopped. And each of these officers, you had 130 years of officers tell you, you shoot until the threat stopped. And that's what he did. And Maurice Cook told you, and I'm not going to go through his qualifications because I'll be here another 30 minutes, but he's investigated everything. He doesn't have to come in here. If you think he's going to sell his opinion and his credibility for $4,000, then there's nothing I can tell you today. But he's testified in state and federal court and in front of the United States Congress, and he came here and he told you that Patrick Tuter's actions were commendable. He said that Patrick acted reasonably as you want an officer to, and that sometimes you have to act when there's houses around, when there's officers on the other side, but you have a right to defend yourself. And the law clearly states that. And don't let them distort the law. Don't let them shift the burden.
Time's up.
Ladies and gentlemen of the jury, Patrick Tuter made split-second decisions to save his life and the life of officers. And the law clearly justifies him. Find him not guilty. Thank you.
Mr. Sanchez?
Thank you, Your Honor.
Yes.
May it please the court.
Mr. Sanchez?
Good afternoon. That's right, Your Honor. Good afternoon.
Good afternoon.
I also want to thank you. I sound like the fourth person saying that now, but I also want to thank you. I know, just like other counsel has said, you didn't have a choice to be here. You were ordered to be here. You received the summons, but you did have a choice as to whether you wanted to pay attention or not. That's one thing we couldn't force you to do. But I think you all took your job seriously. The 12 of you are here because we believe you're 12 reasonable people, 13 reasonable people, sorry. And that's what we're asking you to do here today, is not leave your reason and common sense out there. You came in with your reason and common sense, and we're asking you to keep it, and we're asking you to use it when you go back in the jury room. Okay, so just remember that. Throughout my summation, okay, I want you to remember, this is all about using your reason and common sense. The word reasonableness and reason are going to be all over that chart and have been used throughout this trial, and that's really what it comes down to. Do you really find it reasonable that Patrick Tuter really thought that there was a gun in this man's hands and that he was trying to kill him? Because at the end of his testimony, that's what he said. At the end of his testimony, it went from telling Officer Griffith, hey, he ran me twice, till 12 days later, after he talked to his lawyer, hey, I thought he had a gun. That old tired play that we always hear when officers shoot somebody in the back, that we need to stop. We need to stop buying into that. To, at the end of his testimony, not that I thought he had a gun, he was trying to kill me and Officer Norris. The story got better every time. Now, yeah, he didn't have to take the stand. He didn't have to take the stand, but he took the stand. And just because he's presumed to be innocent, he's not presumed to be truthful. Okay? And he had to take the stand because that's the only way he could raise self-defense. That's all he had to do was say it, and it gets in the charge. But just because it's there doesn't mean it's what is true. So, you know, I've been doing this a long time. I've been doing this, turned 50 this year. I'm feeling it. And when I was a younger lawyer, I would see that prosecutors and defense attorneys would come in front of the juries and they'd shout, they'd pound on the table, they'd come over here and they'd scream, they'd stand in front of the defendant and they'd point at him, they'd get as close as they could. And you know why they do that? Because they didn't have a case. In the 22 years I've done this, I think that's the most I've ever been screamed at by another lawyer. I assure you, that's the most that a defense attorney has ever screamed at me in 20 years. And why? Why is that, you think? Why is it? Because what do they say? When you don't have the facts on your side, you pound the table. And that's what's going on here. You know, we took this case, and I proudly tell you, Philip Hayes and Tom DeMore here, we took this case as prosecutors, and we knew it was going to be tough. We knew that we were going into an area of prosecuting a police officer who killed somebody and shot him in the back, that we were going to get pushback. We're going into...
I'm going to object. This is improper argument, and there's no evidence of that, Judge. That's
Misleading
misleading.
the evidence presented to the jury.
You saw it from the stand. You saw it from the stand. Even some of our own witnesses that we called, because they were the ones that collected the evidence, even them, we're not too happy to be here and cooperate with us. You saw it. I'm not arguing outside the evidence. It was right there, right in front of me. We knew. We knew that. But you know what? But we also knew that a manslaughter had been committed. And actually, we believed it was intentional killing, but for sure it was manslaughter. And we weren't just going to let that slide. So we're here prosecuting it because that's what happened. And we did the best we could with the witnesses that we had. This is not about calling star witnesses. I mean, again, you know, that's theatrics. That's something for the movies, and the star witness comes in, the music stops, you know, and takes the stand. That's not what this is about. This is about real life, okay? This is about real life. This is about, let's remember what this is about. This is about this man right here. This is about his family who's out there right now. The defendant's family is not the only one in here. This is what it's about. Yes, you know, he committed a felony that night. He sure did. We've never shied away from that. We even brought you the evidence that he had committed a felony. We weren't trying to hide that fact. We were being transparent. We weren't going to tell you that he wasn't running from the police and that he didn't have drugs in there. That's true. But the question here is, was it reasonable to kill him for that? That's really what this whole case comes down to. You know, other trials we have to prove the elements of the offense, but these were already proven. I mean, we know that the defendant shot and killed Michael. We know that the fatal shot was the one in the back. So there's no issue when it comes to that. So really the only thing you're going to have to decide when you're back there is, was it reasonable? Do you really believe that he was defending himself when he fired all those shots? And you know, they try to diminish the 41 shots. And we know it's 41 because Patrick Tuter himself in his statement said he had 46. Not in his statement, but he told the investigator that he had 46. 46, 5 left over, that's 41 shots. I mean, I don't know why they even try to make it less than that. If more than 15 shots is not such a big deal, why are they fighting over 5 bullets? But we know that. So really, you're going to have to go back there and among yourselves deliberate and personally think about it. You know, all 12 of you are get back there and deliberate are jurors, but each of you have an individual moral verdict to give. So if somebody disagrees with you, well, guess what? You can disagree. But then what you do, you deliberate. And what deliberate means is you talk amongst each other and you say, okay, this is the way I see things. Well, I didn't believe that. Well, I did believe that. And at the end, come to a consensus. But you don't change your vote either just because you want to be popular with the group. You don't change your vote. If your vote is guilty and that's what you want to stick with, you don't change it because you want to go home at the end of the day. We're getting close to the holidays, because if you did that, then your vote wouldn't be worth much, would it? Your vote wouldn't be worth anything because you're voting in a way that you truly don't believe in. And what we truly have here is manslaughter. It's sad that we have that, but we do. We didn't make that up. Like the defense is trying to tell you, we didn't make that up. The only thing that was made up in this whole case was the imaginary gun that they have to try to convince you existed or thought existed, and the imaginary movements that Patrick supposedly saw is the real gun right here. I'm just gonna hold it up like that, be safe. That's the only real gun that was out there that day, other than what the other officers had in their holster. So let's, you have to put yourselves in the shoes of the defendant in order to deciding whether it's reasonable that he was defending himself, or it was reasonable to use the deadly force to effect the arrest. But let's for a little bit think about what Michael was going through. Yes, he was afraid, obviously. He didn't want to stop. It's a reasonable deduction from the evidence that he was afraid, and that's why he didn't want to stop. He had drugs in his car. And he goes on the chase. Bad mistake. Shouldn't have done that. But he's driving. He's trying to lose him. He can't. He gets to the cul-de-sac, which is really what you're going to have to concentrate on. Gets to the cul-de-sac. He's trying to maneuver that turn. And do you think he got a little scared when the defendant rammed his car? Do you think he got a little bit scared? Or a little bit startled at least? I mean, that wasn't a robot driving that car. That was a human being. And what do you think? And you also have to stop and say to yourself, why is the defense going through these mental gymnastics to try to say that that wasn't a ramming? Why? Why are they saying that? Have you ever stopped to think that? Why did the detective, who didn't even want to file the case, is he looking at the same video that you get to look at and say, well, it kind of looks like a collision. I think he was trying to get in front of him. But you saw when Mr. Hayes was showing the video to the detective. He slowed down to get in the center. That's the only time he hit his brakes so he can position himself better. And then he took his foot off the brakes and hit him right in the middle, dead center. If he was truly just colliding with him, he would have slammed on his brakes to try to avoid that. But he wasn't trying to get in front of him. He already knew he wasn't going to get in front of him if that's really what he was trying to do, but he hit him and he rammed him. And you have to ask yourself, why? Why are they making such a big deal out of that? Okay, it's a collision, it's a ramming. Why? Because you know why? Because if you believe it's a ramming, then you already know that he's acting recklessly. Because by him ramming him, he recklessly put himself in that position. Because you can't put yourself in a place of danger and then claim self-defense later. That's why the ramming is important. That's why they don't want you to even consider that to be a ramming. A collision. I mean, every one of the witnesses that they called kept calling it a collision. Why did we have to go through these games? Even when the defendant took the stand, why did we have to do that? Because it's important. They don't like it. They don't want you to consider that. Because once you get there, then he's the one that's being reckless, but they're trying to say that Michael was the danger. They're trying to say that Michael was the one that's trying to kill him. He said that. You heard it from his own mouth. He's trying to kill him, when all you see on the video is that he's trying to get away. Now, if Michael would have backed up and he was going to run into him, they might have something. If he had backed up and he was going to run in and run over Officer Norris or one of the officers, they might have something. But he was just trying to get away, which is still wrong. But it's not a reason to shoot somebody in the back. There has to be imminent danger to use deadly force to make an arrest. This law, I believe, it's a reasonable deduction that this law was meant for situations where, there's a person who's about to stab somebody, so you got to kill him to keep that from happening. There's another person who's raising a gun and is about to shoot somebody else. Well, may have to shoot him to save that person's life. That's not what was going on here. So don't buy into that. Don't buy into that it was immediately necessary at that point to shoot him in the back. So we know that's not going to be the case. So the only thing left is self-defense. And the only person that provides any evidence about that is the defendant. The one person in the courtroom that has the most motive to tell you something that's not true. He's trying to save himself. He's trying not to take account. He doesn't want to be held accountable for his actions and being reckless out there. So what does he do? He rams the car. We know it. He rams it, recklessly does that against the policies of the police department. Because he's going to win. He's going to win this. And he rams the car. He gets stuck. What happened was he got stuck. The smoke started bellowing. He couldn't see really what was going on next to him, so he decided, and he couldn't open his door, so he decided to shoot his way out by recklessly shooting into the car next to him just to get out of the car. Not because he saw a movement. Come on. Please tell me you're not going to buy into that. Please tell me you're not going to buy into the old, I saw him reaching for a weapon. How many times have we seen that and heard that?
Judge, I'm going to object. He's going outside the record. How many times have we seen
Argue within the evidence presented to the jury in the law.
You live in the real world.
Excuse me, Your Honor, respectfully, could I get a ruling on my objection?
I'm sorry,
Could I get a ruling on my objection?
sustained.
If you instruct the jury to disregard the prosecutor's comment.
I'll instruct the jury to disregard that particular comment.
Last witness, correct?
Denied. Go ahead, Mr.
Thank you.
Sanchez.
We live in the real world. Just because we're in Frank probably doesn't mean that the world has gone away. You know. So he looks over, really can't see it, because he even said, hey, there's a lot of smoke going on, but somehow with my X-ray eyes, I could see that through that smoke and the mud and the rubber, and I saw him reach down for something, the classic, reach down for something.
Judge, I'll object again. The classic will object to that language, arguing outside the record.
This is argument, Your Honor.
Okay. I'll overrule this objection. Go ahead, Mr. Sanchez.
Maybe I'll use another word, the tried and true. How's that?
Again, Your Honor, outside the record, the tried and true. Talking about the facts of this case, he's trying to bring in facts or from other cases or for what he's read in the newspaper, and he's trying to prejudice the jury. We respectfully object to him.
Argue within the facts in this case,
Thank you.
please.
So
I
the court,
respectfully get a ruling on my objection.
Sustained.
I'll ask you to instruct the jury to disregard Mr. Sanchez's last comment.
I instruct the jury to disregard Mr. Sanchez's last comment.
Last witness comment.
Denied.
may I proceed, Your Honor?
Yes, sir.
And Your Honor, if I could give a couple of minutes at the end, because
Sure, I'll give you 5 minutes.
Thank you. So he tells you, and he tries to convince you, because if you did notice though, when he took the stand, he was really good on direct. He could answer every single question on direct. When his attorney was asking him questions, but when I asked him questions, all of a sudden he couldn't remember, or he just wouldn't even answer the question. Because if it didn't help him, he wasn't going to answer it, or he wasn't going to remember. Recall that. He was up there. It was very tough to ask him questions because he wasn't going to answer anything that he thought may not be good for him. So he tells you, he looks up and he sees him lean over. But that's not what happened. He couldn't see through the smoke. He started shooting through the door. He shot his way out, not because he thought that he was about to get shot in the face, because he was stuck. And then he also tells you, he finally moves up a little bit, and he keeps shooting back, kind of over his shoulder, into the car before he gets out. If that isn't reckless, what is? Shooting over your shoulder? You know, they make it sound like these bullets are nothing. Oh, you know, these are rubber bullets, right? I mean, they don't even make it through they can't even get through the door of a car. You know, they're making it sound like they're BBs. They're not. Those are projectiles. You saw the damage that it did to Michael. Oh, they're just little BBs. That's why I was afraid for my life, because they can't go through the door. Well, guess what? When he shot 41 bullets, those were 41 deadly weapons he was throwing over there. Talk about the missile. They keep talking about the car being a missile. How many missiles did Michael receive in his car? So you don't think he was in fear for his life at that point? You don't think he just wanted to get out of there? Who was trying to save his life that day? Mr. Tuter? The defendant? It was Michael. After the first 15, he already had a bullet in his arm. The defendant couldn't even give me that. He couldn't even concede the point that, hey, that might hurt. And that might be the reason he was trying to get out of there. So talk about reasonableness. He couldn't even give me that. He couldn't give you that and say, well, yes, okay, yeah, it could have hurt. He was just going to say, no, I don't know. He couldn't even tell me that Officer Norris was taller than him. I don't know. You have to measure it. How are the cars situated? I don't know. You have to do it. Is that somebody who's being forthcoming with you? Again, just because he took the stand, he doesn't get the presumption of truthfulness. So he's shooting over his shoulder, recklessly, into the car. And what does he do? He gets out. He finally gets out. He finally shot his way out of his situation. Even though there's a phantom gun in that other car, he's going to get shot in the face. People can say anything, right? People can say anything. We have kids, you know that. Doesn't mean it's true. Doesn't mean it should be believed. Because he said, I thought I saw him reach for something, doesn't mean that really happened. And so he gets out, and he's in fear for his life, and he thinks that Michael's gonna kill him and Officer Norris. And what does he do? Talk about video. Thank God we have this video. They don't want to talk about this video. So he gets out. Technical difficulties. Heard this. Do we know the light? So he shoots there, over his shoulder. He breaks away. He's finally out of the reach of Mr. Allen. Pulls his car up, kicks the door, still shooting. And here it comes. You could see he was walking up to the window. He was going to walk up to the window of a guy that he thought had a gun. Is that reasonable? You'll be able to see this video more than once if you want, okay? He was going to walk up to that window, probably to open the door and grab him, because he knew he didn't have a gun. Does it seem reasonable to you that if he really thought he had a gun, that he's going to walk right up to the window? If he had a gun, if he really thought he had a gun, he would have come around the police car, positioned himself to shoot in there. But no, he was going to walk up. And then when the car slides over, he doesn't like that. And he shoots in the back. In the statement, he said he thought he only shot twice. And he shot, the reason he probably only thought he shot twice because they hadn't come back with the bullet count, and they didn't have to account for it then. But that's why they want to make a big deal about the bullets that aren't accounted for. But we know he shot him. So there he is, shooting in the back. But if you look at the video, it's telling. That's, it's very rare that you catch things like that on video all the time in all these trials. Okay? But that's something important, and you need to talk about it when you have to decide whether you believe his account. Because you have to believe him. You have to believe him to acquit him. And we know that's not true. He was on adrenaline, he was mad. He told you the adrenaline was going. And that's probably what caused him to act recklessly. He made bad decisions out there. He made bad decisions too. But he's the one that killed somebody. He didn't have a gun. He did. He didn't hit a car. He did. That's important. That's why these cases are difficult. Because a lot of times the people they kill have been doing something wrong, but it doesn't mean it's lawful. If that was the case, you know what? Once he pulled out from him and put out his lights, why not just start shooting him right there? The law lets him do it, right? No, it's got to be immediately necessary, and it's got to be reasonable. It wasn't in this case. And that's why we brought you as officers. They told you they weren't in fear for their lives. You can look at the video of Officer Norris. I mean, that's their whole case. That's their whole case. That's where they want it. They want you to just not look at all this stuff. That's their whole case because they were able to confuse Officer Norris. If you look at it, you can see a shadow in there. If that's what you're going to rely on to acquit him, then I might as well just sit down. Why even have jury trials? We might as well let Troquel run the show. But that's not how it works. So we bring in those officers, and what did they have to gain? What did they have to gain? What did Officer Norris have to gain by putting himself on the witness stand and get raked over the coals by the defense? What did Officer Griffith have to gain? What did the officer that told you that he said at the very beginning, at the scene, that he had been rammed twice, and we know that's not true, and why is he lying about that? Why is the defendant lying that he was rammed twice when you know that's not the case? 12 days later, changes a little bit though, right? He's not talking about getting rammed twice. 12 days later, it's become the gun. Because if he really thought there was a person there that had a gun, if he really thought that Michael had a gun, he would have told somebody there. He would have told Norris when Norris confronted him. When Norris said, "What the hell? You almost shot me." You think the first word out of his mouth was like, "But man, you know, I thought he had a gun. You know, I'm sorry." Or, "I thought he had a gun," without even apologizing, because we know he probably wouldn't. That's telling. But 12 days later, that's the story. After he is allowed to go, after he's allowed to see the video where he knows that, I guess they're going to know that I rammed him. I have to say it's a collision now. And now they know that I was probably a little reckless. Not a little reckless, but a lot reckless by violating policy. Well, now I got to say something that's going to get me off the hook here for shooting that poor guy in the back. Well, guess what? Oh, that's right. I saw him reach. And there it goes in his statement. And then Officer Troquel, no, he's in no hurry to push this case through. You heard him. You know, just the very fact that from the very beginning, they call these officer-involved shootings, that tells you everything you need to know. Did you see the medical examiner? She called it a homicide. She didn't say officer-involved homicide. She didn't say that. Because guess what? In the end, it's somebody killing somebody else. It's a homicide. But from the very beginning, these cases are treated much differently. Kid gloves. Hey, you all right? You know, you shot some guy in the back. I'll tell you what, you know, why don't you go talk to your lawyer? Go over there. Okay? I'm not going to ask you anything. When you get a chance, you know, when you think about it, come back and talk to me. You know, write me a little something. And the normal procedure in any kind of homicide, okay, come on in. If you're not going to ask for your lawyer, I'm going to talk to you. Now, if you ask for your lawyer, that's something else. But if you're not going to ask for your lawyer, I got to talk to you because I got questions. Because I want to know how you shot this guy in the back, and you're going to justify it. Does it surprise you that so little cases have not been indicted with this kind of investigation that we've seen? Surprise you at all? And then we get the sheriff, right? The sheriff, after the defendant testifies, and after they put on Troquel and the officers that we reserved to cross-examine until today, because we thought that was very important that we hear from the defendant first. They brought you the sheriff, good old sheriff. Seems like a nice guy. But he's the hired gun. He's the guy that goes around the country whenever an officer gets indicted for killing somebody, and he comes in to save the day. How much business do you think he would get? How many $4,000 days and a nice night in Dallas would he get if he didn't testify the way he did? Just because someone's an expert doesn't mean they're not biased. Experts are a dime a dozen. You can buy one and say whatever you want them to say. Again, we live in the real world. We know what's going on. You know as much as he did. Actually, as a matter of fact, you've seen more evidence than the sheriff did. He didn't even see all of his testimony. He came in late. But hey, believe me, I wear a hat. I'm a sheriff. I got all this experience. And it was all right to shoot that guy in the back, because I say so. That's what they brought me. These cases are real. These problems are real. Just because he's a police officer at the time, which makes it a little bit harder for us to prove, doesn't mean we haven't proved it to you. It just meant that we had to work harder. You owe it to Dallas County. We're tired of this. And all you're saying by your verdict is that you're holding them accountable. That's all you're saying. And you're holding them accountable not because I'm telling you, not because anybody else is telling you. It's because the law and the evidence dictates it. It's the logical end. He could have probably turned his life around. He's got a little girl. Maybe he would have gone to jail. That might have been the best thing to happen to him. He would have got some help. He could have been a good father to that little girl, a good son to his parents, a good grandson to his grandfather. This ain't theatrics. This isn't pounding the table. This isn't bellowing up in front of other lawyers. This is real life. So go back there. Have the guts to do it. Find the defendant guilty of manslaughter, because that's what he did.
All right, thank you, Mr. Sanchez. All right, ladies and gentlemen, the jury, I continue to admonish and instruct you not to discuss any evidence in this case with anyone, not even among yourselves. In the very beginning of this case, I told you there would come a time when I would reverse that instruction. This is that time. I'm now instructing you to deliberate and discuss all of the evidence that you've seen, heard, and received in the trial of this case. You'll now go with the bailiff. She'll take you to the jury room where you will deliberate your verdict.
All right.
And Mr. Perry?
Yeah, I know.
Okay, all right. Well, you need anything. Yeah. Oh, it's in the jury room? Yeah. Okay, all right. Yeah. Okay, here, let me put your number down here. No, I just got this. We'll put you back here in Kellen's office. He's got to be. Huh? Yeah. No, I'm up there. I just called him up here because I had Yeah, and then I was just asking her where I can put him because we're just putting him in his office in here. He's got to get his backpack, he's got his stuff in it. So she's getting that for him.
Thank you.
Yeah. Okay.